Welcome to the FCPA training series from Corporate Compliance Insights featuring CCI founder Maurice Gilbert and Tom Fox of Tom Fox Law. Tom has practiced law for 25 years and is now assisting companies with FCPA compliance, risk management, and international transactions. Tom writes and speaks around the world on a variety of topics ranging from FCPA compliance, indemnities, and other forms of risk management. The videos in this series provide an introduction to FCPA compliance for legal, compliance, and operations personnel. Please note, the information should not be considered all-inclusive, and we encourage viewers to seek professional advice prior to implementing any compliance program. So let's get started.
I'm Maurice Gilbert with Corporate Compliance Insights, and joining me in the studio today is Tom Fox of Tom Fox Law. Today we'll be discussing risk assessments. Tom, you told us previously that a risk assessment has key components that relate to compliance program. Can you go into a little more detail for us, please?
Yes, both the Department of Justice and even if you go across the pond to the Ministry of Justice in the United Kingdom, both say that your program starts with a risk assessment. The English have a much more English and probably better way to say it because they say that your risk assessment informs your compliance program. Here we would say that you need to utilize your risk assessment to set your program in place. And the reason is the department does not want you to take an out-of-the-box, canned approach to compliance. They want you to assess your risk and manage your risk. So a risk assessment, it really all starts to designing your program around your risk assessment.
How do you perform a risk assessment?
You know, that's an excellent question because almost every compliance practitioner has heard of a risk assessment, but many ask the exact same question that you did. How do you actually do a risk assessment? The first thing you do is utilize your own company resources. If you can, poll your own employees, talk to your own employees, look at your own company records, look at your company's compliance program, look at your T&E spend, for instance, look at the amount that you have spent on your third parties, look at your third party process, look at your internal controls, interview, review, take a look at what's in place. To the extent you can, benchmark against others in your industry or compliance programs in general. But there's a wide variety of information that you can and should take a look at for your own risk assessment.
What should a company expect to receive from a risk assessment?
Sure, the output or what you receive is obviously a very important part of your risk assessment. But if I could break that down into a couple of parts. The first is what should you receive? The second is who should receive it? And the third is how should it be received? So for instance, you need to make sure your risk assessment addresses the appropriate risk to your industry. If you're in the extractive industries, you need to take a look at where you're doing business, how you're doing business, what types of government interactions you will have. And then who's going to receive the risk assessment within the company? If you don't have a lawyer lead your risk assessment, you will not have attorney-client privilege, which can be important if you want to try to sustain the privilege to any risk assessment that you might do. But moreover, employees who need to understand the risk assessment to help graft your compliance program going forward certainly need to review your risk assessment. But in addition to moving the risk assessment down throughout the organization, you need to consider who's going to see it above you. So the board of directors, the audit committee of the board of directors, senior management should all receive at least a summary report of your risk assessment. And then the audit committee of the board probably needs to receive the full report as they have the overall duty and charge of compliance oversight within your own company. And then the next part is what should they receive? Should they receive the full report? Will they read the full report? Should they receive a summary of the report? How do you take the information that's in the report, translate that into something that people can understand? So one key or very useful technique I've seen is some sort of risk matrix where you risk rank the risk that you have identified and assessed. You may risk rank them within your company. You may risk rank them within your industry. and then you may risk rank them in terms of what can be remediated the most quickly and how they can be remediated. Certainly graphs and PowerPoints lend themselves to this type of presentation, but how you communicate that information, how you get the message across, is a key component of any risk assessment and the output of it.
I'd like you to share with our viewers your 5 key recommendations regarding risk assessments.
Certainly, one of the key points that I think compliance practitioners need to keep in mind is you need to try to do a risk assessment annually. Now, I don't mean a full company-wide soup to nuts, A to Z. We're going to look at all of our risk in every geographic location and business unit. That should be done at no less than a 3-year interval, but hopefully at 2 years. But every year, take a look at new risk. Are we in any new markets? Do we have a new product? Do we have a new service line? Try to understand if the law has changed. Have your risks changed? Is a new government in place? There's a wide variety of things that go into a risk assessment. You should do one annually. Next, I advocate bring in an outsider. Put a fresh set of eyes on it. Not just a second set of eyes, but a fresh second set of eyes. Do not use the law firm that designed your compliance program. Do not use any of the subject matter experts that you utilize on a regular basis. They are certainly appropriate and certainly helpful, but if you can bring in an outsider, it really helps to validate by putting a fresh and second set of eyes. And next, how are you going to use your risk assessment? We started off by talking about a risk assessment informs your compliance program. You should utilize your risk assessment to take a look at any deficiencies that you found in your compliance program, not because your compliance program is substandard, but best practices evolve and best practices change, and that's something that you need to take into account. You should also use your risk assessment in your dealings and evaluations of your third parties. We've talked about how third parties are one of the highest risks under the FCPA, and it's important that you not only assess the risk of your third parties, but use your risk assessment in managing those third parties going forward. In the context of how a risk assessment should inform your compliance program, I think what the Department of Justice wants to see is you moving forward with your compliance program. That does not mean that tomorrow you need to have a best practices compliance program in place. If your program needs updating, if best practices have evolved, if you're in new markets where your risk is greater, higher, or has changed, what I think the department wants is a written plan in place and you moving forward with that plan. So for instance, if you have managed your third-party risk on the sales side, it may be appropriate for you to take a look at your third parties on the supply side. Many third parties come into a company, a business relationship with a company through the supply chain, visa processors, customs brokers, freight forwarders, others who may have government touch points that you may not have considered on your risk assessment of third parties on the sales chain side. Nevertheless, they may put you at equally as at risk because of the government touch points and the possibility of bribery and corruption. So it may be appropriate for you to take a look at your third parties and if that come in through the supply chain, and if so, put a program in place to manage those. The management of third parties through the supply chain will be different than management of third parties that came in through the sales chain. But if you put a program in place, it's documented based upon your risk assessment, and you're moving forward. If you have a violation during the pendency of that time, I think the government will look favorably and upon you because you have a program in place and you're moving forward. And that's really how I would advocate the use of the risk assessment. It's your roadmap for your compliance program going forward.
Tom, thanks for joining us, and we welcome you back for the next in our FCPA video series. Thanks for joining us today, and remember, before implementation of your own FCPA compliance program, you may wish to seek professional advice. Also, as a reminder, please visit us online at corporatecomplianceinsights.com.